back at it again. All right. So, effects of accepting the franchise upon your civil status, entity type, sovereign status within Fed law without franchises, status in Fed law after accepting franchise. Human being born within and domiciled within a state of the Union. Non-resident, non-person without franchise. Private man or a woman. Constitutional but not statutory citizen. See why you are a national, state national, and constitutional but not a statutory citizen. Stateless person, a transient foreigner. Foreigner. And foreigner. After accepting franchise, your all caps letter name, you become a resident alien, non-resident alien, a non-resident alien individual. Public officer, a trustee of the public trust. Statutory U.S. citizen pursuant to 8 U.S. Code 1401 because representing a Fed corporation under 28 U.S. Code 30025A, which is a citizen pursuant to Fed Rules of Civil Procedure 17B, not a constitutional citizen of the United States pursuant to 14th Amendment. Inhabitant, domestic person, U.S. person, 26 U.S. Code 7701A, 30, domiciliary. Okay, State of the Union is a state, lowercase, foreign states, without franchise, after accepting a franchise, statutory state as defined in 4 U.S. Code 11-0D, see Fed Trade Zone Act 1934, a 19 U.S. Code. Trust, foreigner, foreign estate, 26 U.S. Code 7701, A31, non-statutory trust. After accepting the franchise, you're a domestic person, U.S. person, 26 U.S. Code 7701, A30, a statutory trust. State corporation, a foreigner, a foreign estate. Same thing. After accepting the franchise, you're a domestic person, U.S. person, 26 U.S. Code. A federal corporation would be a domestic person, a U.S. person already privileged. And after accepting your all caps letter name, the franchise, you become a U.S. person under 26 U.S. Code 7701-830, person already privileged. All right, participating in any gov franchise, which is the all caps letter name, can leave you entirely without standing on remedy in a Fed court. Essentially, by eating out of the gov's hand, you are screwed, black and blued, and tattooed. The language below comes from the Brandeis rule for the U.S. Supreme Court. These general rules are well settled that the United States, when it creates rights in individuals against itself, a public right, which is a infirm for a franchise to help the court disguise the nature of the transaction, is under no obligation to provide a remedy through the courts. So basically, when you're accepting the all caps name, you can never get a remedy through the court because you're government property. That wherever a statute creates a right and provides a special remedy, that remedy is exclusive. Okay? And then, still, the fact that the right and the remedy are that underlined might not, if the provision stood alone, require U.S. to hold that the remedy expressly excludes a right in review of the Court of Claims, where the decision of the special tribunal involved no disputed question of fact, and the denial of compensation was rested wholly upon the construction of the act. So you can't get compensation from the government because you are seen as a government worker through your all caps letter name franchise. For detailed explanation of why the above is true, see also Allen versus Graham, Signing up for the Gov entitlement hands them essentially a blank check because they, and not you, determine the cost for the service and how much you will pay for it beyond the point. This makes the public servant into your master. Yeah. And beyond that point, you must lick the hands that feed you. Watch out, never ever take a handout from the Gov of any kind, or you'll end up being their cheap whore. The Bible calls this the whore of Babylon the Great. Harlot. Remember, Black's Law's Dictionary defines commerce, e.g., commerce with the government, as intercourse. Commerce, intercourse, by way of trade and traffic between different peoples or states with the citizens or inhabitants thereof, including not only the purchase, sale, and exchange of commodities, but also the instrumentalities, govs, and agencies by which it is promoted, and the means and applauses by which it is carried on. Gov franchises and licenses are the main method for destroying the sovereignty of the people, pursuant to 28 U.S. Code 1603b3 and 28 U.S. Code 1605a2. They are also the main method that our public servants abuse to escape the straitjacket chains of the Constitution. Below is an admission by the U.S. Supreme Court of fact in relation to Social Security. We must conclude that a person covered by the Act has not such a right in benefit payments. This is not to say, however, that Congress may exercise its power to modify the statutory scheme free of all constitutional constraints. All right, so Black's Law's Dictionary defines a franchise as follows: a special privilege conferred by Gov on individual or corporation in which does not belong to citizens of country, generally of common rights. Okay, in England, it is defined to be a royal privilege in the hands of a subject. Oh, wow. A franchise, as used by Blackstone in definition quo warranto, had reference to a royal privilege or a branch of the king's prerogative subsisting in the hands of the subject, and must arise from the king's grant or be held by prescription. But today we understand a franchise to be some special privilege conferred by government on an individual, natural or artificial, which is not enjoyed by its citizens in general. Your all caps letter Nate. In this country, a franchise is a privilege or immunity of a public nature which cannot be legally exercised without legislative grant. To be a corporation is a franchise. The various powers conferred on corporations are franchises: the execution of a policy of insurance by an insurance company, e.g., social insurance, social security, and the issuing a bank note by an incorporated bank, such as a Federal Reserve note, or a franchise. People versus Utah, but it does not embrace the property acquired by the exercise of the franchise, nor involve interest on land acquired by grantee. In a popular sense, the political rights of subjects and citizens are franchises, such as the right of suffrage, effective franchise, the right of suffrage, the right or privilege of voting in public elections, exclusive franchise, the exclusive privilege of franchisee, general and special, the charter of corporation and its general franchise, while a special franchise consists of any rights granted by the public to use property for public use, but with private profit. Personal franchise, a franchise of corporate existence or one which authorizes the formation and existence of a corporation is sometimes called a personal franchise, as disguised from a property franchise, which authorizes a corporation so formed to apply its property to some particular enterprise or exercise some kind of special privilege in its employment, as for example, to construct and operate a railroad. Secondary franchise, the franchise of a corporate existence being sometimes called the primary franchise of a corporation. Its secondary franchise are the special and peculiar rights, privileges, or grants which it may receive under its charter or from a municipal corporation, such as the right to use the public streets, exalt tolls, and collect fares. The franchises of a corporation are divided into one corporate or general franchise and two special or secondary franchise. The former is the franchise to exist as a corporation, while the latter are certain rights and privileges conferred upon existing corporations. So notice the key phrase in England. It is defined to be a royal privilege in the hands of a subject. This is a tacit recognition that a loan of government property is occurring. 1. They use the grant, which is defined as a revocable loan and not a permanent gift. Grant need not convey ownership in the thing granted. Public grant. A grant from the public, a grant of power, license, privilege, or property from the state or government to one or more individuals contained in or shown by a record, conveyance, patent. Damn, they patent people out here, yo. Charter, etc. 2. They use the word in the hands of a subject or subsisting in the hands of the subject, as if to imply that something usually physical is being loaned. 3. The recipient of the loan is referred to as a subject, and a subject is someone who owns all allegiance and obedience to the lender. That's what all debts or loans do. The rich rule over the poor, and the borrower is servant, subject to the lender. Proverbs 22:7. 4. They describe a franchise as a special privilege conferred by government on individual or corporation and which do not belong to citizens of country generally of common right. This means that franchises are not law in a classical sense. Law must be not a special rule for a particular person or a particular case, but the general law, so that every citizen should hold his life, liberty, and property and immunities under the protection of the general rules which govern society. A compact or agreement, but not law. Municipal law, thus understood, is properly defined to be a rule of civil conduct prescribed by the supreme power in a state, commanding what is right and prohibiting what is wrong. It is also called a rule to distinguish it from a compact or agreement, for a compact is a promise proceeding from us, law is a command directed to us. The language of a compact is, I will or will not do this. That of a law is, thou shalt or thou shalt not do it. It is true there is an obligation which a compact carries with is equal in point of conscience to that of the law, but then the original of the obligation is different. In compact, we ourselves determine and promise what shall be done before we are obliged to do it. In law, we are obliged to act without ourselves determining or promising anything at all. Upon these accounts, law is defined to be a rule. So, special law, that applies only to those who consent. Special law, one relating to a particular person or things, while made for individual cases or for particular places or districts. One operating upon a select class rather than upon the public generally. A private law, a law is special when it is different from others of the same general kind or designed for a particular purpose, or limited in range, or confined in a prescribed field of action or operation. A special law relates to either particular persons, places, or things, or to persons, places, or things which, though not particularized, are separated by any method of a selection from the whole class to which the law might not such legislation be applied. A special law applies only to an individual or a number of individuals out of a single class similarly situated and affected, or to a special locality. Private law that does not apply to all citizens. Private law does not apply to all citizens. Private law, that portion of the law which defines, regulates, enforces, and administers relationships among individuals, associations, and corporations, as used in contradiction to public law. The term means all that part of the law which is administered between citizen and citizen, or which is covered with the definition, regulation, and enforcement of right in cases where both the person in whom the right inheres and the person upon whom the obligation is incident are private individuals. They refer to a franchise as a special franchise, consists in any right rights granted by the public to use property for public use but with private profit. They refer to a franchise as a special franchise consists in any rights granted by the public to use property for a public use but with private property. Lord versus Equitable Life Assurance Society. An example of a franchise would be the commercial use of the public roadways for private personal gain. That franchise, in fact, is the foundation of all driver licensing statutes. The following are contemporary synonyms for the word franchise. In earlier times in the founding of this country, franchises were called patronage. 1. Public right. 2. Publius juris. 3. Privilege. 4. Benefit. 5. Entitlement. 6. Excise taxable privilege. 7. Public office. That's what it was called before franchise. It is a franchise. A franchise is said to be a right reserved to the people by the Constitution as the elective franchise. Again, it is said to be a privilege conferred by grant from government and vested in one or more individuals as a public office. Corporations or bodies of politics are the most usual franchise known to our laws. In England, they are very numerous and are defined to be a royal privilege in the hands of a subject. Information will lie in many cases growing out of the grants, especially where corporations are concerned, as by the Statute of 9 and Chapter 20, and in which the public have an interest. And in one strange R, the King versus Sir William Luther, it was held that information of this kind did not lie in the case of a private right, where no franchise of the crown has been invaded. If this is so, if in England a privilege existing in a subject which the king alone could grant constitutes it a franchise, in this country under our institutions, a privilege or impunity of a public nature which could not be exercised without a legislative grant would also be a franchise. Yeah, because we're still under the crown. 8. Congressional created right. 9. Trade or business. All government franchises are contracts between the grantor, which is the government, and the grantee, which is the private citizen. As a rule, a franchises spring from contracts between the sovereign power and a private citizens, made upon valuable considerations for purposes of individual advantage as well as public benefit, and thus a franchise partaking of a double nature and character. So far as it affects or concerns the public, it is a publici juris, and it is subject to governmental control. The legislator may prescribe the manner of granting it, to whom it may be granted, the conditions and terms upon which it may be held, and the duty of the grantee to the public in exercising it, and may also provide for its forfeiture upon the failure of the grantee to perform that duty. But when granted, it becomes the property of the grantee, and it is a private right subject only to the governmental control, growing out of its other nature as publici juris. American jurisprudence. The term publici juris is used above as defined as as follows. Publici juris, Latin, of public right. The word public in this sense means pertaining to the people or affecting the community at large, that which concerns a multitude of people. In the word right, as so used, means a well-founded claim, an interest, concern, advantage, benefit. This term, as applied to a thing or right, means that it is open to or accessible by all persons. It designates things which are owned by the public, that is, the entire state or community, and not by any private person. When a thing is common property, so that anyone can make use of it who likes, it is said to be a publici juris, as in the case of light, air, and public water. Franchise are therefore an outgrowth of your absolute right to contract, and they require either implicit or explicit consent in order for the term of the franchise agreement to be enforced against you. They are public property. Based on the last definition, They always result into a conversion of your formerly private property to public property, a public use, a public purpose, and or public office in the government, which is a polite way of saying that all those who participate must do the following in order to participate. 1. Donate their private property to the public in order to qualify for benefits. 2. Surrender their rights to exclusively own some or all of their formerly private property. 3. Transform from a sovereign to a subject and a serf. 4. Transform from a de jure citizen to nothing more than a Fed employee or public officer on official business. 5. Join a socialist collective called the public or a corporation called the state as a public officer. 6. Consent to transform a de jure government into a de facto private corporation monopoly that not only doesn't protect private rights, but systematically destroys them and makes them illegal for all practical purposes. 7. Consents to allow your donations to the franchise to be illegally used to bribe other people to expand and perpetuate the system and Ponzi scheme. Wow. All right, I'm going to stop here.